We have a very famous, important attorney involving the Second Amendment today. We have Haley Proctor of the prominent law firm Cooper and Kirk and a professor of law to boot to talk about her major win in the Ninth Circuit Court of Appeals in California involving the constitutional right under the Second Amendment of 18 to 20-year-olds to keep and bear arms. Stay tuned. We have a lot to talk about today. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court Bar, best-selling author, and most importantly, proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And of course, as always, feel free to share this video far and wide to all your friends. Okay, guys, we have a very special occasion here today. We have a prominent lawyer, Haley Proctor, from the important law firm Cooper and Kirk, does a lot of Second Amendment litigations. Among other things, she is a professor of law at the University of Missouri, or Missouri, depending on where in Missouri you're from. And of course, most importantly, she clerked for Clarence Thomas and Thomas Griffith. And we're going to talk about those two justices, one justice, one judge, in just one moment. But before we get to that, we want to talk most importantly about Haley Proctor's tremendous win in the Ninth Circuit Court of Appeal in California, where she helped vindicate the Second Amendment rights of 18 to 20-year-olds who were denied, among other things, the right to access and acquire semi-automatic rifles. And we'll get into the details in just one second. So Haley Proctor, welcome aboard. We cannot be happier to have you here at the Four Boxes Diner.
Thank you. I'm so thrilled to be here and honored. Thank you.
Wonderful. Well, before we get into the details of your tremendous win in the case of Jones versus Bonta in the Ninth Circuit, I just want to talk briefly about your background, because a lot of people on this channel, they really love Clarence Thomas as a Supreme Court justice, and they would love your other judge, Thomas Griffith, and we'll talk about him in a second, but they probably don't know him as well because they're not legal geeks like we are. But first of all, why don't you just tell us briefly, what was it like clerking for the United States Supreme Court and Clarence Thomas?
It was such an incredible experience. He is a remarkable man, and I'm glad to know that your listeners so appreciate him. He is a brilliant jurist, but in addition to that, and what was really a wonderful experience to me, is that he's a kind person and a good boss, a good mentor. I learned so much about the law from him during my year there. I always say we would spend, my co-clerks and I would spend weeks wrestling with these legal issues and talking them over and researching them and reading every case. And we would go in to meet with Justice Thomas, and he would ask that one question that gets right to the heart of the issue. He just has that sort of a mind that he's been doing this for 30 years and knows the law so well. And of course, loves our Constitution and has done this, this past term, was really pleased that he was the author of the majority opinion in the NYSERPA v. Bruin decision, to see him really articulating in incredible detail how we go about understanding the Second Amendment right to keep and bear arms, and it was a great decision.
Now, you actually have a little bit of personal experience with the Second Amendment as a law clerk even before you went to work for Clarence Thomas, because you worked for a lower court judge, a Court of Appeals judge in the District of Columbia. And folks, for those of you who don't know, clerking for the U.S. Supreme Court is really one of the highest honors you can have in American law. But another very similar, comparable honor is being able to be a law clerk for a judge on the District of Columbia's Court of Appeals, because so many of our Supreme Court justices start on the Court of Appeals for the D.C. Circuit. And you, Haley, had the opportunity to clerk for one of the famous ones, Thomas Griffith, who has actually multiple very favorable rulings over the years on the Second Amendment. Tell us a little bit about Judge Griffith and his role in protecting Second Amendment rights.
Absolutely. So Judge Griffith was on the appellate panel in what became known as the Heller case, and he was part of the panel that recognized, really for the first time, that the Second Amendment protected an individual right to keep and bear arms. And so that was an incredibly important decision, and Judge Griffith was part of that. And then again, he was on the Wren, in the Wren case in District of Columbia, which recognized after Heller had been about keeping arms, but a lot of courts were reluctant to recognize a right to bear arms, to carry arms outside of one's home. And that was another decision that recognized the right to bear arms. Again, Judge Griffith was on that panel, and he actually authored that decision.
That's right. And we talk a lot on this channel about incrementalism, meaning in order to build a wall, you have to do it brick by brick by brick. And every legal precedent, every case, every sort of authority that's favorable to any constitutional right, including the Second Amendment, is really a brick. And certainly the early bricks involve the right to keep arms, which means the right to possess them, to have them. And then, of course, you have the right to bear arms, which means the right to carry them, which the Nysurpa versus Bruin case just a month or so ago clarified and made it was already clear in my opinion, but they affirmed the obvious, which is the right to bear arms means the right to carry guns outside the home for private self-defense. So that's how that all works. And so, Haley, let me ask you this now. You have helped contribute to another brick in the wall supporting the right to keep and bear arms in your very big win. This was a big, big win in Jones versus Bonta in the Ninth Circuit out in California. This involved issues involving 18 to 20-year-olds being able to keep and bear arms. Tell us a little bit about that case and how did it come about and what ultimately happened with the Ninth Circuit.
All right. In that case, we are challenging a constellation of laws in California that make it very difficult for 18 to 20-year-old adults to acquire long arms and outright prohibit them from acquiring semi-automatic centerfire rifles. With a few exceptions that the Ninth Circuit agreed were not relevant. The appeal here. Well, and I guess I should back up here and say, although it was not a subject of our challenge, under federal and California law, 18 to 20-year-olds are already unable to acquire handguns. So 18 to 20-year-olds in California are in a particularly difficult position because they already don't have access to the class of guns that many consider to be the best for self-defense. And then on top of that, California takes away semi-automatic centerfire rifles and imposes some pretty significant burdens on acquiring any other types of long arms, including shotguns. And so this appeal came about. We, in the trial court, sought a preliminary injunction. The district court denied that under Ninth Circuit precedent, which was, hasn't been very friendly to the Second Amendment. But we succeeded in this appeal to, first of all, get the panel recognized that 18 to 20-year-old adults do in fact have a right to keep and bear arms under the Second Amendment, which was an incredibly important point, and that furthermore, outright prohibiting a class of firearms is a violation of the Second Amendment, and one that is unlikely to survive even intermediate, but certainly the strict scrutiny that the Ninth Circuit precedent at the time required the court to apply. The court did hold that the conditions that California places on their ability to acquire other types of long arms, which includes attending a rather onerous hunter safety course and paying for a hunting license, even if the young adults don't intend to use the firearm for that purpose, that was the court held to be a limited burden that survived intermediate scrutiny because, again, Ninth Circuit precedent required the court to apply a lower level of scrutiny to that law. But that in a nutshell is the decision.
But it's interesting, Haley. You won this case really right on the eve of the Nysurpa versus Bruin Supreme Court victory for the Second Amendment. And you won it under the much more difficult, in my opinion, standard of this sort of tiers of scrutiny, which the people on this channel have been well educated by me over and over and over again, that when you hear the phrase tiers of scrutiny, or balancing test, you run really, really fast away because tiers of scrutiny and balancing test is an excuse. It's a euphemism for allowing government actors, including the government courts, to be able to balance away your right to keep and bear arms. But the Bruin case seems to have come out and really shut down that tiers of scrutiny balancing test. And I'm glad they did. So maybe, Haley, you could talk a little bit about this notion of tiers of scrutiny versus what the Supreme Court did in Bruin, this text and history test. How does that play out generally? And specifically, how might that play out when it involves 18 to 20-year-olds and their right to keep and bear arms under the Second Amendment?
That's right. I think you've explained very well what is so problematic about tiers of scrutiny, because it allows the judge to sit there and decide, well, this isn't that great a burden. The rights here that are being protected aren't that important, and to allow those rights to be balanced away. And that's ultimately what happened in many of the cases challenging the restrictions on the ability of 18 to 20-year-old adults to keep and bear arms. And so, the state would put forward all of these public safety justifications and say, well, young adults disproportionately commit violent crime, and this is a temporary burden. In 3 years, they can get the guns that they need, and this isn't that big of a deal. And so that's what you saw the courts doing, balancing away the rights. What Bruin says, the NYSERPA v. Bruin decision, is that you can't do that. The balance has already been struck by we the people who ratified the Second Amendment and the 14th Amendment, and that whatever right that created is not one that can be balanced away. So how do we figure out what the right that was created by the Second Amendment is? And you look at the text, and you see what it says, and you look at the historical tradition to see if there are any accepted practices that define the contours of that right. So the Second Amendment recognized a pre-existing right to keep and bear arms. What did that consist of, and what at the time that it was recognized and codified, did everyone understand to be the permissible limits that the government could place upon that right? And so the way that plays out with the right of 18 to 20-year-old adults to keep and bear arms is, first of all, you look at the text of the amendment, and it doesn't say the right of people over the age of 21 to keep and bear arms. It just says the right to keep and bear arms. There's no express limitation in the language on the age of the people who can keep and bear arms. So then you have to look to the historical tradition. Well, is there something about the contours of the rights as it was understood at the time? And there again, we see that at the time of the founding, or shortly after the ratification of the Second Amendment, every single state and the federal government defined the militia to include 18 to 20-year-olds and required those 18 to 20-year-olds to furnish their own arms to participate in the militia. And the reason that this is significant, again, gets back to the text of the Second Amendment, because we know that one of the purposes, not the only purpose, but one of the important purposes and reasons for which the Second Amendment was codified is that the framers recognized that in a free society that the militia was an important institution and that people should be able to organize into an armed militia. Well, if the militia was understood at the time to include 18 to 20-year-olds, then and you're seeking to protect the ability of the people who make up the militia to arm themselves, then clearly the Second Amendment must protect a right to keep and bear arms among that group. And the Ninth Circuit recognized that. That's very compelling evidence. And so the Second Amendment does protect that right. And then we get to the question of, okay, well, once you recognize that they have those rights, is there some sort of a historical tradition that would allow the state of California to say, fine, you can buy some long guns, but not semi-automatic centerfire rifles, or allow the state to erect very difficult barriers to the ability to get long arms? And I just don't think that the state of California is going to be able to come up with that history.
Yeah, I think that's right. Haley, it's interesting. You talk about the right of the people to keep and bear arms. Who exactly are the people? And, you make a great point, but sometimes we on this channel have talked about the Militia Act of 1792. And of course, as you know, the Militia Act of 1792 came by the first Congress of the United States, which, of course, ratified in 1791, literally months earlier, the Second Amendment. And, of course, under the Militia Act of 1792, as I recall, correct me if I'm wrong, 18 to 20-year-olds were indeed considered part of the militia that not only had a right to have guns, but actually had an obligation to go have their own private arms to be able to bring them to militia musters if called upon.
That's exactly right.
Now, Haley, are there other examples in the United States Constitution that do limit rights or opportunities for people based upon age? Is there anything in the text of the United States Constitution that actually does limit people by virtue of their age?
Absolutely. So there are qualifications to serve in Congress and to become president that are limited by age. So that's certainly informative. And we've also seen that in constitutional amendments, the people have set age limits when they thought it was appropriate. And so the 26th Amendment is a good example of that, where it recognizes a right to vote for individuals 18 and above. And another reason that amendment is so significant in this context is the history behind it and why it was that the country was so moved to recognize that 18 to 20-year-olds have a right to vote. And that's because they serve their country. They protect their country. And so they should have equal access to the rights of citizens of this country. And for the same reason, if we're going to be sending an 18-year-old out to defend our country with arms, we should also recognize his right to keep and bear arms.
I think that's a great point, Haley. And, I also point out that, we're older than the age of, we're no longer young adults. You might be, but I know I'm not a young adult anymore. But I mention that because, it's often the case in American, employment life, in the business world, usually the younger people who are just starting careers, they're starting jobs, they're often the ones that have to go home late. They get the third shift, they have to work overnight at the hospital. They have to go to work at night because they're the junior people on the totem pole of the, of the escalator of life, if you will. And as a consequence, in many respects, in my view, and also they don't have the same economic prowess in many instances as older people that have had years and years and years to maybe get married and to save money and to buy a house and have better paying jobs because they're young and they don't have that opportunity economically yet. So in many instances, it's the 18 to 20-year-olds that are in the greatest risk of crime because they have to be outside at night. They're coming home late from a nursing shift. They're taking the subway in New York City. They're not driving home in a car because they're too young to afford a car. And again, in some ways, I would argue that 18 to 20-year-olds as a practical experience need firearms more than older people because in many instances they're the ones that are exposed at bad times of the day and the night in bad areas and bad places where you're more likely to be a victim of violent crime.
I think that's a very good point, and I think it's especially true for 18 to 20-year-old women. And I think that this shows just how specious the reasoning that happens, the balancing that happens under the tiers of scrutiny is. If you look at the crime rates that are used to justify these laws, first of all, it's an incredibly small percentage of 18 to 20-year-olds who are committing violent crimes. So you have all of these law-abiding 18 to 20-year-olds who are prevented from exercising their right to keep and bear arms on the basis of the conduct of a very small percentage. But that percentage becomes significantly smaller when you're looking at women. There's simply no that statistic simply provides no justification for disarming women. And the Supreme Court has recognized this in other contexts. There's no other right or other context in which that sort of a statistic is going to support depriving a group of people of a right.
That's a great point, Haley, because it's kind of like the common use test for what kinds of arms, as in the right to the people to keep and bear arms, which arms are protected. The Supreme Court has made it clear repeatedly that if there are arms that are commonly owned by Americans for lawful purposes, they're protected arms. That's the end of the inquiry. It doesn't matter that you have ne'er-do-wells and psychopaths and terrorists and violent criminals misusing firearms or anything else in America. That is not relevant to the Second Amendment because, as you know, among others, Caesar Beccaria back in the 18th century talked about, any criminal can use anything to commit violent crimes. And, we're not interested in limiting our constitutional rights because of the misbehavior of some miscreants. So I think that's an excellent point. So Haley, why don't we just talk briefly? And again, we really appreciate your time here. It's been a great honor to have you here on the show. But just tell us briefly, where does the Jones versus Bonta case that you won, where does that stand in California California. Is the law that you successfully sort of struck down, is that in effect now? What's going on in the court system? What's going on in the political system of California with respect to this issue? Kind of what is the lay of the land right now after your big win in Jones versus Bonta?
Well, and thank you. It's truly an honor to be here. And where things stand right now is that the state has sought to have the case reheard en banc, and or reheard in general. But this is something that we see very often in the Ninth Circuit. Initially, in our federal court system, appeals are heard by panels consisting of 3 judges. But parties can seek rehearing through a process that's called en banc. And what that means in most circuits is that every judge who isn't recused from the case will hear the case. And in the Ninth Circuit, because it's such a big circuit, there are so many judges, it actually just means the chief judge plus 10 randomly selected judges. And usually, every circuit has a different culture, a different practice for how often they take cases en banc. Usually it's a process that's reserved for resolving some sort of conflict in the law within the circuit or for a particularly important issue. But the Ninth Circuit, unfortunately, we've seen has frequently taken up cases involving the Second Amendment en banc. So when good decisions happen at the panel level, the court takes it up en banc and reverses the decision. So that happened in Young v. Hawaii recently, which was about the right to carry. And there was a very good panel decision. Judge O'Scanlan authored. It was taken up en banc. It was reversed, but fortunately, that has very recently been vacated and remanded in light of the NYSERPA decision. So that's good news on that front. But it is something that we've seen often in the Ninth Circuit. So we're going through that process right now.
Good. It's interesting, if you look at the major Second Amendment cases in the last decade or so, we have the Heller case, which basically taught the District of Columbia respect the right to keep and bear arms. Then, of course, we had the McDonald case that taught the city of Chicago respect the right to keep and bear arms. And now we've just had NYSERPA versus Bruin, which taught New Yorkers and the state, not New Yorkers, but New York government and the state of New York, time to respect the right to keep and bear arms. One wonders whether the next blue state anti-gun jurisdiction that might be up for the Supreme Court review might be something out of the Ninth Circuit Court of Appeals in California. Only time will tell. But Haley, we really appreciate you coming on. Is there anything else you'd like to tell our audience about the importance of the Second Amendment from your point of view? And why should people who are not 18 to 20 years of age, why should older people care that 18 to 20-year-olds are allowed to carry guns or allowed to have guns under the Second Amendment? Why does it matter to a 45-year-old that 18 to 20-year-olds can participate in their full-blown constitutional rights under the Second Amendment?
Absolutely. I think there are 2 big reasons. I mean, the first is these are the people who are protecting our country. They are engaged in the defense of our country, and that defense and that responsibility goes hand in hand with rights. And so I think we should care because it's the right thing to do, that they should have the full rights of citizenship. That's the first reason. But the second reason is if you cherish your Second Amendment rights, then you don't want to see the state able to chip away at it with these sorts of very weak justifications like the ones that the state is putting forward in defense of the laws that take the right away from 18 to 20-year-old adults, because you never know when you're going to be in the next group that is deprived of their rights.
Haley, that is great. We have Haley Proctor, a lawyer at the prominent law firm Cooper & Kirk, as well as a professor of law at the University of Missouri School of Law in the middle of our country. Haley Proctor, again, thank you so much for coming on. I know everyone in the audience was appreciating your comments and observations. And of course, we really do appreciate your support in the court of law, fighting for our right to keep and bear arms, which is actually in the text of the United States Constitution in the Second Amendment. So Haley Proctor, thanks for coming on, and we'll see you again soon, hopefully.
See you soon. Thank you.
Orders up. Table 2A.